Welcome to the Courtroom Chronicles. This channel is dedicated to educational content based on real-life cases and true events. This content shared here is drawn directly from the actual case file, and no names, places, or items have been changed. However, the content has been carefully summarized and presented for educational purposes in a comprehension format to inform, enlighten, and spark meaningful discussions. Whether you're here to learn, reflect, or simply understand the real-world scenarios better, you're in the right place. We believe in the power of truthful storytelling to educate and inspire. Disclaimer: while all stories are based on real cases, they are presented in a condensed and structured format for clarity and learning. Viewer discretion is advised where necessary. This case is cited from the Nigerian National Industrial Court online file, which is public record. The case of Mr. Solomon Osemwengie versus Nigerian Agip Oil Company. A man named Mr. Solomon Osemwengie, a Nigerian, found himself embroiled in a significant employment dispute. A long-serving employee of Nigerian Agip Oil Company Limited, Mr. Osemwengie believed that his retirement on March 16, 2012 wasn't by choice. Though tagged as voluntary retirement by his employer, he argued that it was anything but voluntary. Represented by his attorney, Mr. Osemwengie took a bold step. He filed a suit before the National Industrial Court seeking justice and redress. The heart of his case rested on the claim that his retirement violated Regulation 15A of the Petroleum, Drilling and Production Amendment Regulations of 1988 and associated ministerial guidelines. He also accused his employer of discrimination and sought over $600 million in compensation for lost earnings, unauthorized deductions, and various penalties directed by the Department of Petroleum Resources, DPR. But like in any courtroom drama, there were two sides to the story. The defendant, Nigerian Agip Oil Company, argued that the retirement was perfectly legal under Clause 15A of their Conditions of Service, which allowed voluntary retirement between the ages of 55 and 59. According to them, Mr. Osemwengie had accepted his terminal benefits and thereby waived all further claims. They insisted the DPR guidelines and Regulation 15A weren't part of the contract and thus irrelevant. Moreover, they rejected the discrimination claims, saying the comparison to another employee, Mr. Iankoya, was invalid since his contract was entirely different. Lastly, they questioned whether Mr. Osemwengie even had the standing to sue and whether his claims had expired under the statute of limitations. Presiding over the matter was Justice Prof. Elizabeth Oji, who delved deeply into the facts and law before rendering her decision. The judgment unfolds. Preliminary objections dismissed. The judge ruled that the lawsuit had merit. Since the DPR's last official communication was in December 2016 and the case was filed in 2017, it was within the acceptable timeframe. Mr. Osemwengie had the right to sue based on employment-related laws and guidelines. Retirement not voluntary. The court found that the so-called voluntary retirement was, in reality, involuntary. Justice Oji noted that calling something voluntary doesn't make it so if the employee didn't genuinely agree. The clause allowing the employer to unilaterally initiate voluntary retirement was labelled as an unfair labour practice. DPR guidelines and Regulation 15A not binding. The court declared that unless these guidelines were written into the employment contract or legally mandated, they could not apply. She cited previous cases like Pengasan v. Chevron to reinforce that the Petroleum Act didn't authorize the minister to regulate private employment. Discrimination claim rejected. No evidence showed that Mr. Osemwengie had been discriminated against based on protected characteristics like race or gender. The ILO Convention on Discrimination wasn't applicable here. Refund of unauthorized deductions. On a more favorable note, the court found that deductions for items like cars and insurance weren't contractually permitted. Mr. Osemwengie was entitled to a refund of $1,573,970.81. Final rulings. A. The claim that his retirement was involuntary, granted B. The claim for a refund of unauthorized deductions, granted C. All other claims, especially those relying on Regulation 15A and DPR directives, dismissed. The verdict. Who came out on top? Ultimately, Nigerian Agip Oil Company emerged as the technical winner. Of the 11 reliefs sought by Mr. Osemwengie, only 2 succeeded. He did get validation that his retirement wasn't voluntary and was awarded a minor refund, but most of his hefty financial and legal demands were rejected. The reasons for his partial loss were clear. 1. The court held that DPR guidelines in Regulation 15A were not enforceable in private employment unless included in the contract. 2. The DPR had stepped down their directives, nullifying their penalties and recommendations. 3. The judge reaffirmed that contract terms must be explicit. If it's not written, it can't be enforced. 4. Lastly, discrimination claims failed due to lack of solid evidence. Lessons learned. A. Clarity in employment contracts. If Mr. Osemwengie's contract had explicitly referenced Regulation 15A or DPR guidelines, his case might have been stronger. Employment contracts must clearly incorporate any external regulations they wish to enforce. B. Avoid ambiguity in retirement policies. Employers should avoid labeling involuntary terminations as voluntary, as this misrepresentation can lead to disputes and litigation. C. Know the limits of regulators. The DPR's efforts to interfere in private employment matters caused confusion. Regulatory bodies must operate within their legal boundaries. D. Legal strategy matters. Mr. Osemwengie could have focused on unfair labour practices rather than banking heavily on the DPR's now defunct directives. E. Strong evidence is key in discrimination cases. Allegations must be supported by facts. Invoking international conventions won't help if there's no proof of discrimination based on protected attributes. Thus ended a chapter in the ongoing saga of labour law and justice. Mr. Osemwengie walked away with a partial victory, but a valuable lesson in the importance of contract precision and the limits of regulatory authority. Thanks so much for watching, fam. I really appreciate you spending your time with me. If you enjoyed the content, don't forget to hit that subscribe button, drop a comment below, and let me know what you think about the case. I love hearing your thoughts and feedback. And hey, if you felt a connection or learned something new, give this video a like and share it with someone who might enjoy it too. Until next time, stay safe, stay real, and I'll catch you in the next one.